there in my den. I was sitting here in my den at 25 to 10 and thought to myself, I should probably check it just to make sure everything's good because I was going to walk in at 10 to 10 this morning. So I just thought something told me to call reception. I said, so I think I see a Zoom link to come. You're supposed to be there in person. What? Yeah, my mistake. I do that a lot. So I had to run upstairs, take off my jeans, put these on. This was the same. I had jeans in this. Called it, thought to myself, I could drive down there because I live at King Edward Bramble, so it's pretty close. So I thought, I could drive down there. Like find a parking space. Like Uber from there to here. Very efficient. So you know, if I hadn't said that, you never would have known that I would have been late to the meeting. So there you are. So thanks for inviting me. It's the first office meeting I've done here in 4 years, maybe 3.5. Long time. Glad to be with you. It's almost weird in a room full of people. But I agree with Michael. You should come in. When I was a broker, you know, it's like the broker's challenge is get people to come to your meetings and create that synergy that is part of the package. Yeah, agree with that. Okay, so I've got an agenda today on there somewhere. There we go. Oh, cool. That's me. That's how you reach me. I don't think it's hard to reach me. Although by phone it usually is. If you want to, you know, ask me a question or send me a message, it's best by email because I use my iPhone. I can see it. And I'm not, if it's a short question, if it's not War and Peace or something, it's a nice short question. I might even answer it. You know, when I'm down, like after hours, if it takes my benefit. But if you phone me, is that Dale? Dale used to work for me. If you call me, what happens is it goes to my voicemail, and then it somehow goes from my voicemail to my cell phone, and then it sometimes disappears. So don't phone me. I mean, you can. I'm on a message. So email, please. Okay, so I thought today. Next slide, please. Is that in focus? Is that just me?
You're pretty close to it.
Yeah. Okay, cool. I've highlighted what I think to cover today. I'm not covering these. You know why? They have nothing to do with real estate forward. If you're upset about something that had a BCFSA and the BC government, or the federal government, that's these two. But they are coming. So I decided to highlight those. So there's lots of ways you can learn about those. There's a BC REA event coming. I should have written down this month. It's actually quite soon. You go to BCRA's website to learn more about this.
I'm here. They're saying I have my mic on.
Questions? So you can go there. I think that the real estate board is also doing an event with BCFSA staff. It's in December 1st. So we'll let them do it. Okay. This is not really something that has anything to do with what I do. Ditto for this, but you should know, right? So what is that? They're trying to make like a, you know, it could affect things. I mean, if I lived in this way, maybe not. I don't know what it would do around here, but this is Mr. Trudeau's ban on foreign buyers for 2 years. Will that affect your market? That you should be aware of. If you have a foreign buyer, and you'll have to look at what that definition is. But assuming it's someone who doesn't have citizenship, I think that's a foreign buyer. If you're working with one of them, you're to get them sold before December 31st. It's a great tool. Don't know what you can do after December 31st. You can sell them before. That'll be a great close. I do this before. Now I don't know if that's closing before December 31st or cooking a deal before December 31st. So you want to find that out.
You can close after.
Close after.
I just talked to Ken.
Sounds like he knows what's up.
You can, as long as it's a firm deal before December.
Yeah, with the foreign buyers tax. Yeah. That was an anomaly.
I read the act. Yeah, it's still kind of big.
This man has told me.
No, last.
All right, anyway, I'll leave you to, I just wanted to highlight that these things are happening. And it reminded me, I think I'm gonna use this quote in the next call.
Hey, Kim, can you speak it up a bit for
Oh, sorry.
everybody to hear? Thanks.
For who?
Everybody, and including the Zoom. Thank you.
I think I'm gonna put this quote in my next column. Ever heard this quote? I think it was either Lenin or Marx, I can't remember which. He said, there are decades when nothing happens, and there are weeks when everything happens. It kind of feels like that right now, doesn't it? Yeah, all these changes just in the space of a very short time. I wish that the government would, governments would find other shiny objects to pay attention to. Leave us alone for a while. Isn't that nice? Okay. I don't think it's going to change. Frankly. It's gonna be for a long time. So I'm going to talk about the changes that took effect last Monday or October 17th, 2 weeks ago on Monday. I'll answer any question you have. And I thought I would bring this to your attention. It's something that's we've only just become familiar with. You're probably wondering, what is that? Well, I'll tell you. Okay, so next slide. That's what's on the agenda for today. Big changes ahead. And then Q&A. You know, anything you want to ask, it's fine.
You say next slide.
I did say next slide.
Next
Sorry.
slide.
Coming.
There we are. Okay, so if you have saved the rules of cooperation anywhere on any device, make sure it's the October 17th version, because all we do is we just change the date. So by looking at that date, you might be looking at last year's rules of cooperation. Yeah, a big problem with respect to rules of change. Right? So I would suggest that you bookmark them or download them or old fashioned print them out, put them in your desk, make sure it's the October 17th version. Okay.
They're available right off of the paragraph.
Yeah.
Or the
Yeah.
website. So just go in there.
I lobbied hard to get you a button, and you know, whatever it is, IT communications, website design, the board wouldn't give me a button Paragon for rules of cooperation. I'm actually now logging for rules of code too. So you just get them. I mean, you can find them quite easily, but it'd be nice to have one. So yeah, next time you can put there. So next. Okay, here we are. So just to give some perspective to what the rules of cooperation are, they're our MLS rules. And so they used to be called MLS rules and regulations. The reason they're called the rules of cooperation is because Fraser Valley and Chilliwack Board have the same rules. Sometimes they interpret them slightly differently, which is why you run into stuff occasionally with members from other boards because they do things differently. Just the way, you know, we have Canadian laws that cover all the provinces, but some provinces go, well, that doesn't apply to us, or we don't want it to apply to us. This is similar to the rules of cooperation, but generally the words are exactly the same. All right, so there they are there. So you have one set of rules for MLS between Whistler and Hope, which is a good idea because we all use the same MLS system, Paragon. Really should tell you what conduct you should expect from your colleagues and what conduct you should expect from pretty basic stuff. I would suggest that anytime you're having a problem with a colleague about something they're doing that you think they shouldn't be doing, or something they're not doing that you think they should be doing, it's probably something contained in the rules of cooperation as opposed to code of ethics. Code of ethics is a very general aspirational document telling the public what we stand for. This is a private document focused in on the profession where we delineate how we will act in certain circumstances. It's very prescriptive. The code of ethics is very general aspirational. The board enforces both. Okay, next. Okay. There we go. Okay, so sometimes whenever we change the rules, I usually get a call from a member. I usually push it back with my colleague Arnell. When am I going to get the call from the member? Usually it's a grumpy old guy. Elwood, talk to me about this. Why wasn't I told? It's just like it always happens. We do our best to communicate, but people don't open messages or they're not paying attention or something. So I did get that call from a very angry guy, been around for a long time. Whenever I see his name on the display, And I had this debate while it's raining. I'm gonna let it go to the voicemail, but then I'm gonna have to talk to him later because he's not gonna give up. So why don't I just get it over? Talk to him now. So he phones and he says, same old thing, well, these are illegal changes and I don't agree with any of them. No one talked. They should be approved at an annual meeting of the board, one by the membership, kind of like a union vote. We're not a union, we're a professional association. So we had that conversation. Anyway, so we maintain a list of potential suggestions or changes to the rules that come from you. Okay, so when you say that rule's not working, it needs to change. Right? So I keep a list. Actually, Arnell keeps a list. I send it to her. She keeps this list, and that's one thing. And we also at the same time monitor what's going on out there at government land and court land to see if there have been decisions or court cases that happened that require that we change the rules. So we do that as well. That's one. And then when we have our list and it's, maybe a year and a half has gone by, we start meeting with representatives from the other real estate boards to look at their lists, and they look at ours, and then we come up with a list of potential changes that we think would suit all three boards. So it's a cooperative thing between three boards. So who's involved? Well, I'm there. Arnell is there. Those are the two staff people from our board. Fraser Valley has a couple staff people. Chilliwack has a couple staff people. The board's lawyer, Dan Bennett, is there. And then we have represented managing brokers and realtors in that room. So it's not like this is being done in the back. So practicing people. Josh Bath was a rep once. Sandra Wyant, Arlene Chang from Oakland. So we tap people on the shoulder and say, you want to come to some really long, boring, irritating meetings? Usually people say no, but eventually we find it. Okay, so there's input from you. And then once we've wordsmithed the rules as best we can, the changes, Dan Bennett, who's counsel to the real estate board and also handles all the professional conduct stuff, reviews the wording and does an infinite to make sure we don't end up in jail. Then, another one. Yes. And once it's all done, we present the changes to the board of directors of each real estate board. So who's on the board of directors, practicing realtors and brokers, just like you. So they go through these rules that we've been working on for ages, and they discuss them all, and then they vote on them. And if your board of directors approves them, and the other two boards' board of directors approves them, then we pull the trigger on an implementation date. So it's not just sort of, let's change the rules in October. Okay, that's the process. I actually wrote this because I thought he was going to be at my meeting that I held 3 weeks ago with 800 people. It was online. It's the biggest Zoom meeting I've ever done. It was recorded, so you could watch it because I go in detail about these rule changes, and I'm not going to do that today. Anyway, I thought he was going to be at the meeting, start chirping at me. So I thought, let's turn this first. So he goes, okay, it's like this. The biggest change is that first one. So if I could characterize the changes to the rules, if you wanted 10,000 foot view, big change to delayed offers. Okay, well, I'll cover that in detail with you now. And more generally, if your seller instructs you to override a default requirement in a rule, and there's about 10 rules that allow your sellers to do that. So if it's one of those rules and your seller otherwise instructs in writing, that written instruction generally now must be put into the listing as an associated document, as opposed to what it was before, which is you'd have to ask the seller's agent, well, Doug, I don't actually trust you. Do you really have that instruction? I want to see it, which caused some friction between members. So now the default requirement is put it as an associated document. I mean, that's basically the big changes. There's some other housekeeping changes as well that you can look at. In the column that I wrote that was really long, that was published on the 14th of October, you could watch that video, which was really long, it was 2 hours. And then I made 9 videos detailing the changes on each one of the rules. And 5 of them have been posted, they were released on Friday, the other 4 is, so we really are kind of hoping that, you know, you're not gonna see it, it's no rules change. All right, next slide, please. Yeah, so this is the article that I wrote, October 12th. Okay, so you know, if you were online, you can just scroll up, all these are live links, and then there's a lot of text there, changes. What I did was I printed the rule with the changes underlined and in bold within the rule. And then I gave the little paragraph underneath it called Kim's take. So what does that mean? And I wrote it. So just take a look at that. Next slide. Yeah, that's the backup. So there is a side-by-side document you can click on. It's at rebgv.ca, and it shows the old rule and the new rule. That's exciting. Okay, so I just wanted to, you know, like I'm not around all the time. I can't reach you. You can't reach Doug or Michael. So this is where this is the stuff you go. This stuff.
I have a question, kind of, not you directly on this one there. What about kind of on getting some blowback to spread box and it's values and we have both come.
Okay, well, I'll cover that because that's one of the changes.
Right, thanks.
Yeah, and I'm doing this from memory. So normally when I teach this, because when I do Zoom, I would be sharing screen and I'd be going online and I'd be scrolling through. Look at, I can't have that from memory today. So always go to what I've written or what I've said online rather than listening because I could make this. Okay. All right. So there you go. Is there any more? Could be wrong. Join. Or not. Okay. Yeah, there's some videos and member meetings. Okay. I think that's that slide. So you can turn it off. I'll just talk to you about.
You turn the lights on?
Yeah.
There.
Okay, so let's talk about Rule 4.02. Give you a little history lesson and then talk about what the changes are. How many of you have been a delayed offer presentation where you've been acting for the buyer and you feel like you got screwed? That's a very emphatic.
Yeah, yeah, over here,
Yeah,
yeah.
yeah.
And how, more than once, just once, continuously? Yeah, it's been a frustrating situation, and so I'll give you some context for how this whole thing evolved, because we've made a significant change, and this change is intended to try and address those concerns and your clients' concerns, because I'm sure your clients aren't very happy either, and that spills over, and they form an impression of all of us, which is if you don't like our 48% approval number, it's stuff like that that creates that number. I think we could get to 60. That's an aim of mine. I mean, I'm getting on, so maybe it won't happen while I'm still working, but that I think is achievable for all of us. 60, 90, like nurses, no, they save lives. We're physician salespeople. 90s, 60. I think we can get there. I really do. At 55, 60. You know, what would we have to do to get to 60? Well, fix
Stop
stuff
being
like this.
Yeah.
Okay, so back, I started the board in 2006. And when I started the board, there were no requirements for delayed offers. In fact, the practice didn't even exist. So the default requirement in the rule about presenting offers to the seller has always been the same. It's never changed from when it was originally written, probably 50 years ago. It's still the same today. You have a right to have your offer presented without delay. Those are the 2 words in the rule. They've always been that way. Without delay is not defined. So if everybody's in Yale town, I would say without delay means today or this evening, right? If someone's in China or Germany, you know, I would say that without delay means something a little bit different, maybe a couple of days. Someone's got COVID, you know what. So we leave that up to you to define what without delay is. But your committee, your professional conduct committee would have its opinion within the context of a complaint as to what without delay means, right? Okay, so that's the default. And then somewhere around 2008, 2010, market was pretty busy. And we first started to experience as sellers agents where we would have 50 calls on a listing. We get that here. We got to beat that up. There we go. Perfect. So we first start to get these situations where sellers agents would get 50 calls on a listing. which seems quaint because I understand there's been way more calls than that, in subsequent years. And so they're going, understand, put yourself in their position. Maybe you've been in that position, you get 50 calls. I get stressed when I have 14 voicemail messages. So, 50 would be a big deal. And so they're trying to manage all of this. And so then they were getting, 9 or 10 offers, which seems quaint, perhaps, because there's been offer presentations with way more. I think the record's 75 for the real estate board. That's sort of an anecdotal thing. So you've got 50 buyers, 40 buyers, you're the seller's agent. Someone came up with the bright idea of trying to manage the flow of excitement in people by saying, look, relax. You can show it on the weekend at the open, come Saturday, come Sunday, whatever you want. You just relax. It's okay. You'll get it. And if you want to write an offer, we're going to be presenting them on Tuesday. Okay, so just relax. Come, take a look at the place, bring your inspector with you, write an offer on Monday, and we'll present them all on Tuesday. It's a really good idea for listings like that, where people were feeling like, they're desperate to get in. It was a nightmare for the seller's agent. The sellers were getting stressed. So when that started happening, there were no rules as to how things would be choreographed. And as a consequence, what would happen is people would say next Tuesday, and then a buyer would go, well, I don't want to wait till next Tuesday. You can't tell me not to write an offer. I'm going to write one today. And it's Friday. So that, the seller's agent would get the offer and they go, well, I guess I should present it. And then they forget to call the other 47 members, or they'd call 40 and they'd miss 7, and there were all these shenanigans. So over a period of years, we've tried to address those things. First of all, by saying, okay, if you're going to override without delay, it has to be overridden in writing, signed by your seller. That was the first change we made. We thought that would be good enough. Now, because buyer's agents were saying, I don't think you really have instructions. And I think most sellers agents didn't have instructions. They'd say things like, well, I was told to do that, but I could get them in writing if you need me to. Remember that? Yeah. And so we said, okay, then we moved from that to got to be on the Schedule A. Got to be on the Schedule A, because then they do sign it. And then it was, you have to provide it to buyer's agents who ask for it, but only if they ask for it. And then we started noticing that this system, we were thinking, was actually educating aggressive buyers to write early offers to kick the door in. We actually think that, our best faith efforts to help you with this problem created another problem, which often happens when you're in the rules business. Is, now buyers are going, well, I'm just going to kick the door in with an early offer. And maybe the seller's agent isn't all that strong, and, they'll get forced into doing something by their seller, and they'll forget to call people. So then we go, okay, so now you have to call people to let them know an early offer is coming in. That was about 2014. And then but sellers agents were forgetting to call people because they didn't have a list. And so then we moved the onus to buyer's agents. Said, if you want the seller's agents to call you, you've got to give them a written notice that you want them, so they could create their list more easily. But it was still a nightmare, right? It was still, and then people were saying things, well, my sellers gave me those instructions. They're my clients, so I have to follow the instructions. And technically that's true, except if there's a carve out, and there is a carve out, right? So that's how that all happened. So you know what? We thought about making that delayed instruction irrevocable some years ago, but we didn't want to go there. We thought it might be just a bit too far, a little too intrusive, because we can't tell sellers what to do. So we didn't do it. But then we heard the Winnipeg board had made delayed offer protocols irrevocable or irrevocable, whatever you like to say. And so I phoned the guy who does what I do for Winnipeg board. So how's that going? He said, it's going pretty well. So we decided we would make that change with the approval of the people on the committees and the directors there. So the way it works now is this: it's still without delay, unless otherwise instructed by the seller in writing, using the form. So no more Schedule A, don't need that form. You just need the form. And the form is now been designated as a required document for the listing. So it's tied it all up beautifully. And it's an irrevocable direction regarding presentation of offers, which means if you're my seller, I'm going to say to you, we can do offers without delay. Right now, that's probably what you're doing, right? You're just glad to get one. Yeah, but it's going to change. what, markets come and go. Just a whole different set of challenges depending on market. So I'll say to you, looks like we're getting a lot of action here. And you don't just have to do it when it's a new listing. You can pull the trigger on a delayed offer form 3 weeks into a listing if it looks like things are hotting up. So I'd say to my seller, I'd say, okay, look, we're getting lots of action. Let's get some excitement going and get all the offers presented at the same time. Buyers get excited and they usually pay more, and I'm working for you. So let's do that. The seller goes, yeah, that's a good idea. Okay, if you want to do that, there's a specific protocol I'm required to follow. And I would not be able to accept instructions from you to look at an early offer. I wouldn't be able to accept instructions for you to tell you what's in any early offer that might come in. Okay, it's going to be next Tuesday, and you can't cancel the listing to get out of this irrevocable instruction. We will not accept any changes to that form at all, or it'll be unacceptable to the real estate board. Are you sure you want to do that, seller? Seller goes, yeah, cool. Are you sure? You can see informed consent's going to be a big thing. How well you explain this to your client, and whether you're driving the bus or the client's driving the bus, those are the two key things that I can think of. Okay, do you drive the bus or did your client? If your client's driving the bus, it's going to be a nightmare. I would just take offers as they come in. Your client has hired you because they trust you and they trust your advice, and they'll take your advice, then maybe talk about that. Okay, so no changes to the form, no early cancellations. It's got to be on the form, and you can't deviate from what it says on the form. And the form says, nope, I can tell you I've got an offer before next Tuesday, but I will not present it because you've instructed me not to irrevocably. And that includes offers that are more than for what you're asking, the listing price. And it includes offers that might expire on Monday night. You're agreeing to this, okay? Are you okay with that? And if they say, yeah, sign here. It's also still used for saying to buyer's agents they can't attend at the presentation, but no one does that anymore. I mean, I used to sit in the car out in front of the house with your buyers. How quaint is that? It's actually pretty cool. You can see who else had offers, you see them coming and going. People bang on the door. Yeah, can't do that. Well, you could. I mean, that's your default right. Your default right under the rules is to be there when your offer is presented. Did you know that? You probably know that. Sellers agents will say, email your offer. Well, you don't have to. You can say, no, I'm going to be there, which might be weird. I know, but that's your default. So you use the IDRIPO form for saying buyer's agents can't be there. All right. So if you're going to go down those tracks, you cannot change. Absolutely. If you change and you accept an instruction from your client to reveal that offer early, you're going to get a $15,000 to $20,000 fine. That is what the fines have been for breaches of the previous protocol. So I can't imagine the committee would do differently. I mean, it's not like me fining you. Your colleagues on the committee decide guilt or innocence and what the fine will be. But precedents are, 15 grand in courses and embarrassment and all that. So don't go there unless you're firm. So we did one other thing. In compliance, section 2 of the rules of cooperation, which is probably something you've never looked at before. I quote numbers all the time, but this compliance section is a whole section that just gives context to what your obligations are to follow the rules. I call it the terms of service section. When you use a credit card, when you have a telephone, to use that system, you're agreeing to their terms of use, right? When you update your iPhone, I agree. Do you ever read those terms? Nobody does. In fact, they conveniently place that checkbox before the 400 screens of, blather that they put into their terms of service. But that doesn't mean you're not obliged to follow them, right? So basically, by being a member of the real estate board, you're agreeing to the terms of service of the real estate board and the MLS system, and indirectly so is your client. So section 2 now says you cannot accept an instruction from a client to override a requirement of your association. And so sometimes people try to argue, well, it's a lawful instruction by my client, so therefore that should give me a carve out from following that particular rule. No, you're a member of the board. These are your rules. You've agreed to them by being a member of the board, and indirectly your client has as well. When they use the MLS system, they're agreeing to these rules. So it's actually there, right there now. So you could actually print out section 2 or do a screen grab. And if your client wants you to override something, is pounding their shoe on the desk, you can point at that rule now and say, well, I can't accept that instruction. And if there's I think there's a lawyer, comes he here yet?
Yep, that's it.
Yeah, so I mean, he will probably tell you that the bar association has, his professional association has rules that he can't ignore at the instruction of a client, right? He can't accept it. It's the same for us now, okay? That's what that is. Doug, did you have another one?
Yeah, just.
Oh, the
just one about
Stratadogs.
The Stratadogs,
Yeah,
yeah, what, we have to post them, or what's the deal there? Just clarify.
What's the
that.
deal? Okay, yes, you have to post them within 24 hours.
The Stratadogs?
Yeah.
All?
Yeah, good point.
I thought that there was, if you have them on order, you can put the order up.
Yeah, let me take it from the top.
Yeah.
Okay, so the rule has always said, for 25 years since I've been at the board, or however long it is, seems like 25. You will, and these are the words, at the time of taking the listing, those are the words in the rule, you will have the required documents. That's what the rule says and has always said. And then a few years back, because of rush fees being so expensive, we thought, well, if we start interpreting that literally for silver agents, we're making them incur rush fees to comply with the rule. It seemed unreasonable. So we added a little thing that said, if you've ordered the documents on a non-rush basis at the time taking the listing, it's all good. So that's why the MLS part requires either. Now, your seller can otherwise instruct. This is one of the 10. Did you know that? Your seller can instruct you not to get the rules. I'm not saying you should do that because you've got to then facilitate for the buyer's agent to get them, and it gets messy and so forth. That was put in at the demand of the Competition Bureau to assist posting brokerages in doing what they do. So it's, it was a requirement that we put in the rules some time ago. So this is one of those otherwise instruct situations. And so if you get the written instruction not to post, guess where that now has to go? Associated document. So just think about it that way. If I've got some seller instruction to override a rule, post it as associated document. And your question was, do we have to post everything?
Yeah.
Well, no. What's required in the rule, it's quite a long list, but I would suggest that the council minutes where they might identify an individual, no, those don't, when you provide them to the buyer's agent, but the bylaws, the financial statements, the strata plan, that's public record information, so you put that in up there. Okay. Did I answer your question?
Pretty much, yeah.
Yeah.
I think, Chris, you okay with that?
Yeah.
Chris is okay, I'm okay. I think that's good, Kim, you kind of covered it all.
All right, so that's the rule. So the only other thing how much longer do I have?
You can get looking about 5.
Good, I'll do it in 5 then. So there was an email that came out from the Canadian Real Estate Association when 10 days ago. Probably most of you didn't click on it. It said it looked like a big snore. Always arrives in 2 languages. And it's always really long. Do you get those? If you're on the mailing list, you got them. Did you do that? I can't do that. I have to read them. Okay, so CREA has done something quite edgy, and we're wanting to get input from members through their brokers as to what position we will take.
Thumbs down. We're talking about exclusives, right?
We are.
Yeah.
Okay, so here's the deal. You are not required to list on the MLS system if you're in a real estate board, right? It's your choice. You can list exclusively, which most members don't. But sometimes they do. There's particular reasons why they do. Really expensive property, owned by Brian Adams or, whoever. They don't want to be on the MLS system. So it's sort of one of these private, it's for sale, it's listed exclusively. Commercial business is done like that a lot. So CREA is concerned about, for example, private WhatsApp groups where they're called off-market listings, where properties are being, marketed to just a group of people never hitting the system. The data never goes into the system. Other people might be disadvantaged. And so it's thinking, well, we should address that. It actually got the idea from the National Association of Realtors in the US where, so monkey see, monkey do. I guess we thought we should do that up here. That's where it came from with some changes. Shouldn't really have put it that way, but so
That's exactly.
am I being recorded? All right. So they came up with the rule. Here it is in a nutshell. If you take an exclusive listing for whatever reason, that's fine. You can do that. No one's saying you can't do that. And you can market it within Century 21 in-town realtors. So you can do feature sheets, you can promote it, you can talk to them about it, because it's all brokerage, as Doug pointed out. The brokerage owns the listing, not you. I know it's your listing, but technically the contract's from the seller and the brokerage. So, it can be promoted in the brokerage as much as you want. But if you want to go next door to Dexter and tell them about it, either electronically or by phone or just delivering a flyer, or you want to put up a for sale sign on your exclusive listing, or do some just listed cards, anything that's qualifies as being public advertising, which is everything. It will trigger a requirement to put that listing on the MLS system within 3 days. Okay, so that's the thinking behind it. And some members are, okay, fine, I don't care. I have a list exclusive, I don't care. Other members who maybe do a lot of exclusive listings, are kind of, I'm not sure whether, how I feel about that. And we're not sure how we feel about that. So we're looking for some input as to what you think. There's been a little bit of backpedaling, Michael, since that email came out, because I kind of think that there's been some pushback, not from us, but from other parts of the country. So there was an email that came out from the CEO of Korea yesterday that said, so we're thinking that we might make the change in the code of ethics and put the requirement in there rather than asking 110 real estate boards to change their regulations. So there was some pushback there. We might just make it an article in the code. But also, and if that's the case, then it has to be voted on at the General Assembly, which they were just basically saying, well, we're making the change. It's effective July 1st next year. And people are going, well, how can you make that change without, no one talked to me about this. It's the same thing, right? The other thing that they're saying that maybe is a bit of backpedaling, they're saying, okay, so on a one-on-one basis, you could contact someone from Dexter next door and tell them about your exclusive listing. They're trying to deal with these WhatsApp groups or these private groups that promote off-market listings. They're concerned about that. Maybe it's from a competition perspective, I don't know. But it's also weakens the system, the data doesn't go in. That's the thinking. So if you have thoughts about it, tell Doug, tell Michael, and they can shoot me an email with any concerns that you might have, or if you love it, also let us know. I mean, we're not going to say we hate it just to be ornery. If members are fine with the policy, then we'll say fine. Okay.
We can ask, he's got one question. Does that also apply for assignments that are restricted by developers from being?
Thanks for asking. There's two carve-outs to the policy, commercial and developers listings. But they didn't provide a definition of what those are within the rules. So I suspect that would be a carve-out. It's an interesting question, though. How would that affect an assignment where you're acting for the assign or you're trying to sell the place because you can't qualify for the mortgage and current rates, so they can't close. They're trying to get out from this deal. Yeah, that would be interesting.
Another quick question here.
Yeah.
Regarding that group thing again.
Yeah.
Can we market exclusive listings on FB groups within the system, or will it require to be put on MLS too?
Yeah, the question, did you hear that? The question, WhatsApp, same as Facebook. It's sort of anything that's a private marketing group, that's what this is intended to address. So the answer would be no, you have to put on MLS within 3 days. So I suppose the way it would work is you list it on Sunday, right? You put an effective date of the listing for Thursday. And you have an exclusive listing between Sunday and Thursday. Because right, that the effective date is where your rights get triggered. I mean, did you know that? Probably most people don't know that. They sign it today. Then let's make the effective date a week from now so they can paint the place and have it cleaned up. For that week-long period, you have nothing, no protection. Did you know that? Another person can come in and sell your listing the listing doesn't actually start ticking until the effective date. So you could make the effect. And so to cover that risk, sometimes members will exclusively list between Sunday and Thursday. And then the exclusive ends and the effective date of the MLS listing, it's been pre-signed, takes effect. A little known fact. Okay, so that might be the way that that would work. So you take it exclusively, you promote it in the office on Monday, you tell your WhatsApp group about it on Tuesday, that triggers the 3-day requirement, and it goes live as effective on Thursday. That would seem to me to be within the context of what they've described.
This is the biggest pushback gonna come from the seller. I mean, most 9 times out of 10 is the seller who wants that exclusive versus
Yeah.
the realtor who pushes for an exclusive.
Yeah, I
So,
mean,
like, what are you gonna say to your seller? I can't tell anybody about your listing except for by word of mouth
in my
in
office,
my office.
right?
So it's gonna put them in a hard spot saying,
Well,
oh,
and that's a concern that's been expressed. What do you do with a $25 million penthouse where the seller doesn't want it generally, what doesn't want it picked up by Vancouver's Awesome or CTV and, put out there. They want it done discreetly. That's why you would have an exclusive listing. So if that's something that's important to you, then you should let us know. I mean, opinions we've heard is,
Well, this isn't a rule yet. Is it?
no, it's an announcement that the board of directors of Korea have approved that rule, but it doesn't take effect until July 1st, 2023. And they're now, I think, realizing that just for the board of directors to make a change like that without input from, licensees, members at an annual meeting is maybe a little bit of a bridge too far. So now they're saying things like we want to hear from you. And maybe you could on a one-on-one basis, go next door and tell them about your exclusive listing, that kind of thing. So I think my take on it is, I think they've realized that maybe they were a little too aggressive with it. There's always reasons why you do these things. And they're not done out of malice. They're, if you're a bureaucrat or someone like me, you make these changes or suggest them to address an issue. It's usually done from a good place, but sometimes the consequences aren't thought all the way through because they're lovely people there, but they've never bought or sold anything. There's probably no practicing people at Korea. The board of directors are wrong. But staff starts these policies. And not a criticism of that. Okay?
But so we could type everything up and just shoot it to you?
Well,
Concerned.
I prefer not to get lots of messages from a million people, so shoot it to Doug. Doug
And
will,
I'll save them all up and I'll shoot them one.
yeah, seller.
yeah, hopefully you're gonna take out all the repeat stuff and the swear words.
Yeah, I'll take all of that. Yeah, don't worry.
Yeah.
I'll filter it for you. I know how delicate you are.
Oh, God, you should see my inbox.
I know. Any other questions? We got Ken Pazder coming in, and we're gonna take a quick break here. But just like to thank Kim for coming in.
My pleasure. Thank you. Good stuff for my column, let me know. I'm always thinking, I've written 500 since I started, and I'm running out of topics. Think about it. Every 2 weeks, got to be something new.
Thanks, Kim. Appreciate your time. Good to see you again. Thanks again to Kim. That was very informative. Lots more rules, lots more paper, lots more things to think about ahead. But I think the takeaway from Kim at the end of the day is we have to pay attention to what changes are being thought of and proposed. And if you don't pay attention, you deserve what you get. Just like doing your voting, if you don't vote, you can't complain about anything. So keep reading the information that's coming across. Those of you that don't know Ken Pazder, in my opinion, is a phenomenal real estate lawyer. We do a lot of business with him. He's here to help you and your business. He's here to get business. So if you need a real estate lawyer, I strongly would recommend my friend Ken to all of you. And what are your topics today?
We go to 10 topics, 11 topics.
Wow, okay, well, I'm not gonna repeat all 10 or 11. Could you make sure you speak up so the people on the Zoom can hear you too? So welcome, Ken.
Just in case there's some new people here that haven't met us, we're a real estate law firm downtown, a few blocks from here. We've been doing real estate for about 30 years and we've completed about 30,000 transactions. So probably more than everybody in this room combined.
Are you still closing on Zoom?
Sorry?
Can you still close on Zoom, your deals? Can you close the transaction? on Zoom?
No, that's pretty much gone.
Okay. all right.
Yeah, so the Zoom thing we could do for the last 2 years because of COVID. But the lawyer who does the Zoom sign up, well, I guess I'll just backtrack a little bit. If the client has COVID right now, yes, we could do a Zoom sign up. If they don't, no, we can't. So the idea, there's very few people left with COVID out there, so no, that's pretty much gone. It's still available if the client is super sick and contagious, someone could do a Zoom sign up, but pretty well no lawyers are doing that anymore, no notaries. So just so you know. So the reason we're here is, I think the topic was how to stay out of trouble, how to not get sued, how to not get reported to the real estate board or the financial services authority. And I think the way to do that is just basically by what Michael was saying. You got to read the new stuff. You got to follow the rules that come in as they come in, because they seem to be changing all the time. One thing I've noticed is residential real estate has become a lot more like commercial real estate. Okay, so commercial real estate has more issues. There's more stuff to be aware of. But residential real estate, since we started 25, 30 years ago, the contract's longer, the disclosure's longer, all the terminology, there's more rules, more taxes, more legislation affects real estate now than ever before. So the fact is, your client, believe it or not, thinks you know all this stuff. You're a realtor, so you're trained to, find a good property for me or sell my property. But they assume you're trained in tax and you're trained, you're a building inspector, and you can read titles and read through all the covenants and everything else. And to some extent, that is, of course, it's a mischaracterization by the client, and you kind of have to set them straight of what you can do and what you can't do. So to me, the worst thing you can do when your client asks you a question, do I qualify for this exemption? And you don't know, you say, yeah, I think so. Well, yeah, you're good. And you don't know, it's wrong. You might as well say nothing. So the best thing to do if you don't know is just say, well, we check with your lawyer, check with your tax accountant, call the property transfer tax department, or I'll help you find out, and maybe I'll check with my resources and see if we can find an answer for you. Well, the one example I can tell you, a client a few years back, the realtor had assured them they were a first-time buyer, and we, of course, told them they weren't before closing, so it was about $7,000 tax, and the realtor ended up paying it out of his commission because the client couldn't close the deal. So again, first-time buyer exemptions, you guys don't have to worry about much here because there's almost no properties under $500,000, so you're not going to be running into that too often in the Lower Mainland. And surprisingly enough, the BC government, I wrote to them and asked them when they're going to extend the first-time home buyers exemption. They said they have no intention of doing that. So it's $500,000, and there's a small exemption up to $5.25. And they felt that it will push the prices up. If they increase the exemption for first-time buyers, it'll push the prices up. I couldn't figure out how that would be, but they wrote back to me, and that's what they said. So first-time buyers are out of luck. So what we're going to just mention here today, I've got a bunch of topics. I'm just going to hit the really basic parts because we can spend half an hour on each one of these. These are some things that just there's kind of a basic stuff you should know. So one thing that always comes up on residential real estate that everybody ignores is GST. Okay. So when you guys write a contract, interestingly enough, there's a clause, I know 10 or 11, talks about GST certificates that lawyers pass around to each other on the closing date. That doesn't really do anything for you because all it means is the lawyer who's for the buyer sends a certificate off to the lawyer for the seller and says, well, is this exempt or not? And the seller then will say it is or it isn't and send it back. And of course, most of the time it comes back saying, yeah, it's exempt, it's used property. But sometimes it doesn't come back that it's exempt, that it's actually payable. And so if you don't say what the GST consequences are in the contract, the buyer pays. Because it's a buyer's tax, it's not a seller's tax. The seller collects it, but the buyer pays it. So whether GST is payable or not on a residential piece of property depends on what the seller was doing with the property, not what the buyer is going to do with the property. So I'm going to live in it. Okay, that's a residential use. It should be exempt. It's irrelevant. The seller was using it for short-term Airbnb for the last 2 years. That's a commercial use. That's going to be subject to GST. Okay, so even though it's a used residential property, it's being used for commercial purposes. Would you know that necessarily as a buyer? Maybe, maybe not. Okay, I had a client where my client sold a property to somebody else. It was used as an office in a downtown tower. It was used as an office for the past 2 years. It was subject to GST. That actually killed the deal. So I always suggest to you guys, when you write an offer, you put a clause in your offer that says this purchase price is inclusive of GST if GST is applicable. Okay, so that way you don't care. It's applicable, too bad, it's paid. It's not applicable, it's too bad, it's irrelevant. So unless you want to do a bunch of investigations yourself, I mean, I've seen clauses in there where you say, oh, the buyer and the seller will do their own investigations. Well, no one does. Okay, yeah.
I just had one recently where a new build just completed. My client bought it as a resale. So we put in there that GST is like not applicable, and then the buyer or the seller to remit to the buyer. And then they, on the completion date, it was remitted back to my buyer. And then they also met, or was my understanding that that's the way it was addressed in the contract as per the lawyer's instruction.
Okay, well, so it's a little more complicated when someone buys a brand new place, pays the GST on it, and then resells it to someone else before it's ever been occupied. So in some cases, the GST could be paid again. In some cases, it's not. But in any event, if you put a clause into that effect, you won't care, because whatever tax consequences there is, they're thrown onto the vendor, which is where they should be in the first place, because only the vendor knows if there's GST or not. Okay, so then you don't have to worry about it. Now, if the guy comes back on the offer and says, I'm crossing that clause out, then I guess I would say, as the purchaser's realtor, why? Are you telling me there's GST? So now I can tell my client he's paying an extra 5% on the purchase price, and perhaps you can tell me why. Okay, so GST, again, everybody knows there's GST on a brand new property or a substantially renovated property. That means it's completely renovated 90% or more and nobody's lived in it. But these other cases where there's other uses of the property, you may or may not know those. So as I say, put the clause in, and if the other side doesn't like it, there's a red flag for you. Then you can do some extra investigations and ask the seller, why are you charging my client GST? And then your client, trust me, may want to back out. I don't want to pay an extra 5%, or in the case of, at least they know. One thing clients hate is surprises, because they're always bad. Real estate doesn't have any good surprises, they're always bad ones. So if your client is aware of it, fine, I can live with that, go ahead and close the deal. But one thing we all hate is to be surprised with a bad surprise. So as I say, GST is not going away. It's not, there's a new GST new housing rebate for brand new properties, but it cuts off $450,000. So again, it's out of sync with reality as well. So there's not too much worry about a GST rebate. So I still see sometimes realtors put clauses in there on new properties. This guy and that guy will apply for a rebate. It's $1 million property. There's no rebate. Okay, so it's $450,000. There's no rebate after that. Okay. The other thing that's been changed recently is if any of you guys are flipping condo assignments, okay, so you buy a pre-sale and you resell it before it closes, the government has recently changed the law, and basically those flips are always subject to GST. In the past, sometimes they were, sometimes they weren't. Now they're all subject to GST. So just so you know, your contract, your standard assignment contract says that GST is included in the assignment price. So that's fine. You can change it if you want, but otherwise it's included, and it's always payable now. Okay, but it's only payable on the lift. Okay, the old rules prior to a few months ago, it was payable on the lift plus the deposit, which didn't make any sense because you're paying tax on the deposit. But now it's just on the lift. So just so you know, in case anybody's doing some assignments of resale contracts. Okay, selling a tenant.
Just want to go back to that, Ken.
Yeah.
When, let's say the original price was 500, the new price is 600.
Yeah.
And the contract says that GST is included. There's an assignment, the assignee will go to the lawyer and pay the 600,000, and the assignor has to pay the GST.
No, the other way. Yeah, the assignor is getting the money, right? So he's assigning his interest for the $100,000 lift.
Yeah.
So he's gonna have to pay the $5,000 out of that, give or take.
And who
5,000.
pays that contract, is that just the lift or is it the full purchase price?
No, just the lift.
Okay.
Okay, and then the original purchaser will pay the full GST on the original purchase price to the developer. But what I was saying before is CRA used to say that you're gonna pay GST on the lift plus the deposit. Because you guys' assignment contract says the assignment price equals the lift plus the deposit. All you're doing is paying the seller back for the money that he put down with the developer. So CRA was making you pay GST on that. That's changed. You're only going to pay GST on the lift. Okay. Okay. If you're selling a property with a tenant in it, okay, and there's lots of tenants in there, you guys know the rental market is very tight. If you fill in your clause that deals with possession, so you're going to put in what if you're selling a property with a tenant that's still in there? Are you going to put in vacant possession, or are you going to put in subject to the tenancy being there? Anybody? Exactly, subject to the tenancy. Oh, but I'm going to give him a notice under section 49 of the Residential Tenancy Act, so he's going to be out. Well, that's fine, you can, and he may be out, but he may not be out. Okay, so if you're a landlord, you cannot guarantee vacant possession on the possession date. So if there's a tenant in there, always put in the possession subject to the existing tenancy. You can also put another clause in there if the guy wants it, that you'll give notice under section 49 of the Residential Tenancy Act. Okay, so that means the tenant gets 2-month notice, 3 months rent, and he's got to be out at the end of 2 months. Okay, that's 2 clear months, not just 2 months. But sometimes tenants don't get out. So if the tenant doesn't get out, or the tenant may challenge that notice for no reason, just I don't like the notice, it's irrelevant, I didn't get served on time, whatever. Then the Residential Tenancy Board sets a hearing. And right now the hearings are 2 to 3 months down the road. So if you've got a closing date at the end of this month, and this 2-month notice is coming up at the end of this month, and the tenant disputes that, you're going to give the guy vacant possession probably in January or February. That means you're in default under the contract. The seller's in default. You can't give possession. Okay, so always put in that clause. If there's a tenant in there, subject to the existing tenancy, you can tell it. You can say to the other side, if you give me a written notice asking me to terminate the tenancy, I will do so. But then you're still, if the tenant doesn't get out, too bad. That's the buyer's problem. Okay, you've given the notice, he can inherit the problem. And for what it's worth, nowadays, with the rental market being this tight, I just had a case for just this exact fact pattern. The realtor put in vacant possession. They gave the notice to the tenant. The tenant was some law student at UBC. He wrote a 25-page reasons for why he's not going to get out. Okay. Went to the Residential Tenancy Board. Again, that was 3 months down the road. My client ended up paying $15,000 to get out. Okay, because that's the other way to have a terminated tenancy by what's called a mutual agreement to terminate tenancy. Usually you have to give up something to the tenant if he's going to sign that. So my client did. It was an expensive property. So anyway, that's just a lesson to be learned. Use the clause if there's a tenancy in there. And by the way, if it's a fixed term tenancy, you can't give any notice to terminate. Okay, so fixed term tenancy, you got to let it run out. So only the month-to-month tenancy can be terminated like that. And if anybody has any questions, just jump in as we're going ahead. Yeah.
What's just like which is like and commercial is the board and residential is the board. So the seller is original seller now, and I see I noticed basically I noticed that the city tax is only one tax. about GSTs, when the buyer is buying on the commercial, they put three GST, how does it separate? Because one unit, but it's partially residential, partially commercial, are they going to separate it or?
Yeah, well, that's a good question. I think it partly depends what the client was using it for and how much of it is commercial. Again, that would be something I would say, talk to your accountant about. Because again, you see, you get into these gray areas where you go, well, I don't know, it could be this, could be that. We fall into the same thing sometimes too when clients phone us. If we can research it and get an answer for you, we will, but if we don't know, we'll say, okay, here's a tax lawyer, here's a tax accountant. This is all they do. Okay, so it's just, there's gray areas. Every single piece of legislation is like that. So you can always go, okay, does it go this way or does it go that way? When we're the same, if we don't know, then we'll tell you that and we'll see if we can find out.
Well, one of the realtors actually, because of buyer, he mentioned that there's some kind of clause from the government regarding the city tax, that if it's an original buyer, like 2 years ago, that they grandfather they pay one tax. But if anyone is buying it, that they will be somehow the two city tax. It's not about GST. But that GST up.
Keep the other thing in mind about GST or any other kind of tax, they change a lot. Okay, so when I write a blog on our website, I always put a note on the bottom saying this is true as of today. But next month it might not be true because the government can change things. So just like the GST on assignments, that's a recent change. And again, unless you're in that field, you're not going to know. So always, whatever advice you have, you always have to update it because 2 or 3 months from now it could be wrong. And the government keeps changing things at a very rapid pace. So here's another one we run into a lot: adding a client to a contract. So Jim and Joan are buying a house, and it turns out we have to add mom and dad onto the contract because it'll help us qualify for a mortgage. So here's a question. I see this all the time. The buyer reserves the right to add mom and dad to the contract. It's in there. It's a lot of times, or whoever it is they're going to add. Here's a question for you. Does mom and dad have to sign anything ever? Can you add someone to a contract and they don't have to sign it? No, of course not. But we see realtors all the time doing that. And I even see notaries on the other side and occasionally lawyers too. They send us in the documents. I go, okay, well, you've added somebody because it says you can. They haven't signed anything. And you haven't assigned the contract to them either. So if you're going to put a clause in saying we're adding mom and dad, for God's sakes, at least have mom and dad sign the addendum saying, yes, we agree, we're going to be bound by the contract. Because when you have to sue someone after the fact because they didn't complete, you can't sue someone when they didn't sign the contract in the first place.
Do you have to name that extra party?
You should. And they should sign on the contract saying, I agree to be a party to the contract. It's not a big deal. It's no big deal.
Used to say something generic on that. They didn't put the name.
Okay, but even if they say generic, who are they adding? That person should be signed.
Well, like they say, or that person named it. I can't remember what it was. But it's very, very vague. Or add somebody to the contract, add whatever.
Yep.
There's nobody to sign. No name.
Right, but then somewhere along the line there should be an addendum having that person agree to be bound by the contract. So, for example, if you try to do that with the developer on any of these pre-sale contracts, they just won't close. Like you're not adding anybody to anything unless they sign our own assignment agreement. There's 2 ways to add a party. You can assign the contract to them in full or in part, or you can do an addendum and everybody signs it saying, guess what, Bob's now a party to the contract. But Bob can't be a party to the contract unless he signs or unless he agrees to an assignment. Okay, so there's no big deal.
Just a Dr. Down question on that. Are you saying that the parents have to sign the original contract?
No.
Just
No.
the addendum?
Oh, just the addendum.
Okay, all right.
Did it have to be named in the original purchase?
No.
Okay, that was my question. Okay, I see that.
No, if you say we have we can add a third party, okay, well, I'm a third party, so that takes care of your clause 20A, which says you can't assign a contract. You got a clause like that, but the guy still at some point has to sign something because when that contract goes south and the seller's lawyer wants to sue everyone, how's he gonna sue that person? Who says, I didn't sign anything. Besides, I didn't even agree to do it. So how are you gonna prove anything?
So if you added this person like, in an addendum, that they have to sign that addendum when they're waiting on the addendum as being added to the contract.
Absolutely.
Sign
What if I
it.
buy a property from Doug and I name you? We're gonna add you to the
Yeah, you
contract.
don't have the
We don't
authority
even
to
talk
add
to you.
without my consent.
Exactly,
Okay, gotcha.
exactly. We just assume, of course, you want to be part of that contract.
Okay.
Okay, so anyway, just, it's no big deal. Do the assignment, have the new person sign the addendum. Okay, then you won't run into any problems. Okay, so here's another one we run into a lot, speculation and vacancy tax. I kept thinking that thing's gonna go away when there's a new government, but it looks like we might have this government for a while. So you don't need to put speculation and vacancy tax clauses into your purchase agreement. Still see that a lot. Look at the standard form contract that's disappeared out of clause, I don't know, 11 or 12, whatever the one is about the certificates, it's gone. And most lawyers haven't even looked at the contract in years. They still throw these certificates into us and we just throw them away. But I still see them in the body of the contract in clause 3 under terms and conditions. Oh, the guy will, he's made a spec tax declaration, et cetera, et cetera. Why do you not care about a spec tax if you're a buyer? Bingo. Goes with a seller. Says seller doesn't pay it, that's their problem.
It doesn't do it properly.
So you can forget about the spec tax if you're acting for a buyer. If you're acting for a seller, you can just remind them, well, make sure you pay the spec tax, because even after you sell this property, if you didn't declare for the previous year, the government's going to come after you for 0.5%. Okay. Empty homes tax, because you guys are in Vancouver, a lot of properties you guys are going to buy and sell, or the clients are going to be subject to the empty homes tax, which I believe is going up to 5% now. It's unbelievable, but anyway. So that one stays with the property. Okay, so you want to definitely put those clauses in your agreement. The sellers made the empty homes tax declaration, they'll provide proof and such. Now, when we order a tax certificate from the city of Vancouver for $70 or $80 now, they will put a note on there saying there's been a declaration, it's declared occupied or whatever. But the fact is, it doesn't hurt to put those clauses in for City of Vancouver properties for empty homes tax. Now, the other thing I always recommend to clients, you title insure the purchase, because if you've done your due diligence and it turns out the sellers made some false declarations last year or the previous year, because the government can go back 2 years on the empty homes tax. So I buy the property today, a year from today, there's an audit and they say, hey, the previous owner didn't make a declaration. Okay, so what am I supposed to do about it? I didn't own the property. But the tax stays with the property.
Can you buy title insurance?
Yeah, the lawyers always, we always recommend title insurance. So we would get the title insurance from usually First Canadian Title or Stewart's. And in a case like that, yeah, they would pay the tax.
In one of the Jones tax clauses, it says like that they filed for the previous year. Could we reword that saying they filed it for all years?
You could.
Yeah.
It has been, I think it was the end of 2016 or 17. That's when it came in.
Yeah.
And yeah, you could say that.
Okay. That would kind of alleviate that.
Well, a little bit. They're just making a representation that said, yeah, we filed it all along.
Yeah.
The fact is, the city may disagree with them and say you filed it, but you were wrong. You didn't live there, or it wasn't occupied for 6 months.
Yeah.
So that's the only downside. And title insurance, that's one of the items we're going to talk about a little bit later. But does everybody know what title insurance is? Anybody? Yes, no. Okay, so it's a policy of insurance. It's been around 25 years in British Columbia. First title insurance company actually started in our office in the same building in our office, as they sublease some spaces called First Canadian Title. And since then, they've done millions of title insurance policies. So it's a policy of insurance that protects your title. But it protects more than the title. If you're buying a house, it'll protect against survey problems, encroachment, stuff like that. It'll protect against unpaid taxes like the empty homes tax, like even special assessments. If somebody did a special assessment and you didn't know about it, you got title insurance, that would be covered. It covers things like buying a house that didn't have the proper renovation permits, and now you find out later that there's a bunch of problems and you gotta fix them all, usually title insurance will pay for that. So it's a whole grab bag of about 32 different coverages. Title fraud, things, people do an identity theft on your title, that would be protected as well. Somebody puts a mortgage on your property, that's not you, they sell your property, that's not you. That does happen, believe it or not. So it's a one-time premium and it's good for as long as you own the property. Okay, so it's something we always recommend. We go through what it is, we put it in our retainer letter to the client, explain it. I would say probably 75% of the clients we deal with, they end up taking the title insurance, but it would cover off something like the empty homes tax if it came and hit you in the rear later. So what an insurance company does when they pay out, they subrogate to you, to your interest. That means that, sorry, that's my phone. It'll just. So they subrogate to you, which just means they step into your shoes, and in your case, they would sue that other owner. Say you made a representation that you filed all these declarations and you didn't. But that's their problem. You don't care about it. Your tax thing has gone away. The insurance company will sue on as if they were you, but you don't have any liability, you don't have any costs.
How much is that one?
Title insurance for condo, like say up to $1 million, you're probably looking at $200-300. It's a little bit higher. The higher price, the higher the premium. Say for $3 million, we just did one the other day, $5.7 million property. I think the title insurance was $3,000. So considering on a $5 million property, you're paying $50,000 or $100,000 worth of tax just to buy it. $3,000 isn't a bad thing. So unlike regular insurance, title insurance, you just pay it once, you're done. Okay, there's no annual premium, there's no deductible, and it's a good value for money considering what you're putting out a lot of money on a real estate purchase. So it's better than a lawyer's opinion. You don't have to sue anyone if you're covered under the risk. You don't have to sue. You just make a claim, and title insurance company still, believe it or not, more or less pays in BC because they've only been here 25 years. So they're still trying to impress people that they actually pay claims. Okay, so in other parts of the world, like the United States, where title insurance started, they act way more like a real insurance company where they never like to pay. Okay, so because I had a U.S. real estate attorney buying a property here in Vancouver, and I said, "Oh, we're going to title insure it for you." He goes, "Well, which bit is that?" I live in California. I'm a real estate attorney. He says we fighting them all the time to pay. Well, here they actually pay. So to me, at least for the time being, it's not a bad thing to have. Okay, another one, foreign buyers tax. Okay, so you guys all know what that is? Yes, no? Okay, so it's the extra 20% you pay. You're buying residential real estate in most parts of BC if you're not a Canadian citizen or a permanent resident. Okay, so that's a big hit on $1 million property. That's adding $200,000 to the purchase price. So a lot of times people say, well, do I qualify or do I not qualify? And so we had a case last year, exactly on point, where both the realtor and the mortgage broker, who are both being sued now by the client, said, you're exempt. You are not going to pay the foreign buyer's tax. It's about an $800,000 condo. So to add $160,000 to her, she didn't have it. So we extended the deal. Finally, the seller said, screw you. We're terminating the deal. They kept $60,000 of my client's money. They were generous enough to let her keep 20. So the deposit was about 80 grand. They could have kept it all because, as you guys know, if you default on a real estate contract, you lose your deposit. British Columbia. It doesn't matter if the seller loses any money. The seller can turn around and sell a property for more money the next day. You still lose your deposit. Okay, so that's that. Unless it's an exorbitant deposit. Say at 20, 25% or less, you're going to lose it. Okay. So in this case, we negotiated with the seller's realtor or the seller's lawyer, and they graciously let my client keep 20 grand. But they kept 60. So now my client's suing the realtor and the mortgage broker because they both told her in writing with emails, you're exempt. And why was she exempt? Because she was immigrating to Canada She was in a fast track immigration program, and they thought there's something called a BC nominee program. So under the Property Transfer Tax Act, you can be exempt if you're qualified under this BC nominee program and the nomination hasn't expired, or if it has expired, you've already applied for permanent residency, the government will exempt you from the 20%. That's what they thought they were telling her, but she was in a different program, which had nothing to do with that. Yeah.
I have a question about it. So if someone applies before they got their PR.
Yep.
And if they pay it.
Yep.
I have heard of, I'm hoping to confirm that. If they pay it, and then within a year, when they get their PR, they can get it back. Is
Yes.
that accurate?
That's right.
Okay.
I had a client
Yeah.
over there. The strange part of that, though, this is bizarre. I had a client do exactly that. And we paid the tax on his behalf. About 3-4 months later, he got his PR. So we immediately applied to get the money back. And they said, oh, no, you have to wait a year. It's only been 3 months. No, so we're applying now because a whole year has gone by. But yes, you're right. The problem with that strategy, though, is the immigration department at the best of times, it's kind of like Revenue Canada, they're pathetic. So they can take a year, 2 years, 5 years, there's nothing you can do about it. And the case I was telling you about, my client kept phoning them daily. Can I get my PR? Because she'd already applied and she still doesn't have her PR. That was last year. So the problem is, if you're going to do that strategy, it's a real roll of the dice whether you're going to get that permanent residency status within the year. Yeah. Which one? The foreign buyer tax? No. No, it should, but it doesn't. It doesn't apply to farmland either. So this is a problem. What's happened is the foreign buyers have piled into commercial real estate and farmlands. They're buying up all the farms here. They're buying up all the commercial real estate. So why on earth the government wouldn't make 20% on everything? It's a mystery to me. Because all it does is move the money from one area to another area.
What about January 1st? So it's like farming commercial at that point?
I don't think so. I haven't seen anything about that.
If you're a Canadian citizen, but you haven't paid taxes, you live in the country for, I don't know, 10+ years, you're still exempt.
Yeah.
Okay.
Yeah. So again, the problem with all these different taxes, they all have different thresholds and they all have different, in your case, that can mean it's something for a different tax act. But for the foreign buyer's tax, no, if you're Canadian, you're good. Even if you live in Hong Kong, you live somewhere else, you pay your taxes somewhere else. On the other hand, the spec tax says, oh, no. You can be a Canadian, you can live in, here's a strange thing about the spec tax. So there's a couple, they buy a property in Vancouver, the wife works here, she makes 50 grand a year, the husband works in California, makes 500,000 a year there. Are they going to pay the spec tax? And she lives in the property here with the kids. Are they going to pay the spec tax in or not? Yep.
How about the vacant tax on commercial?
Okay, just 1 sec. But my question was, are you going to pay spec tax in this case? Husband and wife own the property. Wife lives in the property with the kids. She makes 50 grand a year, lives in BC. He makes 200 grand a year and lives in California. No, they're paying the spec tax. They're called a satellite family because their combined income, they pay more tax outside of Canada than inside. So this is so.
Yes, they pay the tax.
That's it. They pay the tax. That's
How
right.
much is speculation?
2%. So it varies. If you're a Canadian citizen and you're not a satellite family member, it's 0.5%. If you're a satellite family member or a foreigner, it's 2%. So again, for your case, so it matters in that case, but for foreign buyers tax, no, it doesn't. You're Canadian, you're a permanent resident, you're exempt. So there's so many different taxes now, and everyone has a different. There's this thing called the landowner transparency tax. That has a different threshold. So every just one tax after another. Did you guys know, for example, there's something called the Federal Underused Tax Act? Anybody heard of that? It's in effect as of January this year. So it's like the spec tax, but it's put on by the federal government. Okay, 1% on any property in Canada. Like, it's only BC has these crazy taxes like this spec tax and the MP homes tax and landowner transparency registry. No other province except parts of Ontario have these I consider ludicrous taxes. But this federal tax will apply across Canada. 1% tax if you don't occupy the property enough. Now, that's probably ultra virus. The federal government, I think, doesn't have jurisdiction to do that. That may wind up in court, but for now, starting January 1 next year, there's a federal tax as well. Okay, Canadians are exempt and permanent residents are exempt.
Sorry, I didn't understand. So is it like the same tax on commercial property? Is it like some kind
No,
of-
that one's, this federal one is just residential property,
Oh, that's-
but it goes across Canada. This isn't a BC tax. This is a
What's the
federal.
threshold?
Trudeau put this in.
Yeah, what does the federal government consider unused? How many days?
Same thing, 6 months.
Okay.
But again, the difference between this one and the ones we have, if you're a Canadian citizen or a permanent resident, you don't even have to file any. So like the spec tax and the empty homes tax, you still have to file and you say I'm exempt, I live there. This federal one, you don't have to file anything unless you're in a different category. I didn't even know that tax was in effect. I know they talked about it, but a few months ago, they put it into law and it's effective across Canada, starting January 1 this year.
It's called the federal unused property tax.
Yeah, it's an interesting one. So anyway, there's just one thing piles on after another. So cooling off period, I don't know if the gentleman here before talked about that. You guys know that's all coming in on January 1, supposedly. So again, I'm sure you'll get a lot of memos and all sorts of stuff from the BCFSA, you know, talking about cooling off period, and probably be included in the contract from now on. But just as the market cools right off, we need a cooling off period. Yeah, that's you know the government's always going to be behind on stuff, but it'll just throw one more wrinkle in the pot for you guys to say, here you can walk away from the contract in 3 days for no reason. Okay, but you have to pay 12.25% penalty. So where are you going to get that money from? So unless when somebody makes a no subject offer and you say, okay, if you want to make this offer, we need the deposit. Because if you back out, we need to be able to take 0.25% of the purchase price and keep it. Because if there's no deposit at the time, you're going to have to chase the buyer for that 0.25%. I don't mean you, I mean the seller. So, you know, just one more thing for you guys to be concerned about. And this is why I say these contracts keep getting more and more complicated. There's one more monkey wrench in the mix that probably is really not necessary. I'm not even sure what will happen if you were in a really busy market and you have these cooling off periods. It'll just make things totally crazy. You guys all know there's a rescission period for pre-sales. If any of you bought a pre-sale, you have a 7-day rescission period instead of 3. There's no penalty to back out. And basically that's been around forever. Okay, so the reason they sort of borrowed that from it's called the Real Estate Marketing Development Act, which governs pre-sales. So they sort of borrowed that cooling off period and said, well, let's make it 3 days instead of 7 days, and let's put a penalty in it. Whereas in the 7-day one, there's no penalty. So if anybody buys a pre-sale, you can always walk away within the 7 days for no reason. So, you know, like I said, I don't want to throw cold water. I'm sure you guys are all going to have a great career, and in the market, I'm sure will start picking up next year as soon as the interest rates start coming down. But I mean, just these kinds of things that I just mentioned are like super basic. Like they're just stuff you should know. And again, if you don't know, don't say you do know. Just say you're fine. I don't know the answer, but I can help you find out.
Okay.
Well, you call me. Sometimes we can answer it. Actually, most of the time we can answer. And that doesn't matter.
I get a question from the Zoom.
Yeah.
Is a buyer considered a foreign buyer if they're on a work permit?
Yeah, they should be, because the exemption is just for citizens and PR. And so again, the work permit, if it was this provincial nominee program, they could be exempt from that. But again, it's a technical thing. You can look at the page on the BC government's website. You have to have applied for this BC nominee program. So BC wants certain kind of people to come to British Columbia, certain skills, certain trades, certain professions. So if you apply and they approve you, then you have a certain period of time where it's in effect, and then it expires. But if you've applied for your PR during that time, and the immigration department will give you a letter saying, yes, we've got your application, it's in the mix, then you can be exempt. from foreign buyers tax. But again, there's 3 or 4 different programs under immigration. If you're not under that one, then you're paying the 20%. So it's always good to check and say, well, what program are you, where's this work permit? Where did this come from? Is this the BC nominee program? Because as far as I know, that's the only one that will exempt you from the foreign buyers tax. So again, the problem is there's these different rules for different legislation, different programs. It's like first time home buyer. For CMHC, that might be you haven't owned a home in 5 years. For the BC government, you haven't owned a home forever, anywhere. Okay, so again, it's okay. Well, which one is right? One's right for CMHC, one's right for the BC property transfer tax. So it's a lot to sink in, I know. Especially then you also have to, get some listings and sell some houses. That's kind of like a small detail, but these are things, if you pay attention to them, if you're not sure, again, you can always check with Doug or Michael. You can phone us. If the client has their own lawyer, their own tax accountant, or their own accountant, that's a source as well. You can always tell them to phone the government. GST has a GST line. We'll answer some questions. Residential tenancy branch, believe it or not, has a half decent group of people that answer the phone there. It may take you an hour to get through, but they actually will give you a decent answer. So again, there's all kinds of resources out there. I'm just saying, don't guess. Worst thing you can do is guess. Any other questions? Okay.
Yes.
I think, thank you, Ken, very much. I think that big takeaway, I think it's like that big takeaway is we're not lawyers, we're not accountants. Everything's changing. So when you get one of these questions, refer it to the authority that handles the accounting or the legalities of it.
Make sure you introduce yourself to Ken and get a card. You're gonna need his advice, right?
Yeah, absolutely.
Right?
Yeah, he always answers the phone.
Right?
It's great.
Yeah, I mean, yeah, he's great.
Yeah, like I said, he's first class in my
Yeah, and refer your business to him. What I always do is I refer my client to them right off.
And then,
They retain him, and then I can use him as my legal advice always.
Yeah. So thanks, guys, for coming in. We'd love to see more of these faces on a daily basis. Get out there. It's going to be tough. It's going to be tough for a while, so you got to work a little harder than the competition. So thank you. Thank you very much.